Good afternoon and good morning, everyone. Thank you very much for joining our We're Under Cyberattack, Now What Cyber webinar. I am Jillian Glover, the Marketing Manager for the Under Cyberattack package. Just a few announcements before I hand it over to our presenters today. This webinar is being recorded and will be available on the Under website next week. You will receive a copy of the presentation along with the streaming link via email. And finally, please note that all lines are muted, so if you have any questions, please utilize the questions chat box, and I will relay your questions at the end of the presentation. Okay, let's jump right in. Along with Jason Bucher, our Senior Underwriting Manager, we are very excited to also have John Mullen joining us today. John is the CEO and founding partner of Mullen Coughlin, a data, privacy, and network security cyber law firm, and the cyber breach response team associated with the Under Cyber Protection package. So John, I will hand it over to you. Take it away.
Well, great. Thanks, everybody, for joining today, and hopefully we can shed some light on a topic that still is relatively tricky to sort of get your head around. I'm going to blast through a bunch of stuff today. I think we have about 30 minutes or so. We're going to welcome questions toward the end, so go ahead and send those in. I think there's a facility to do so, but I'll let these guys explain that. But here's the short version. So let's talk about, why don't we jump to the next slide? So my firm, by the way, will handle in excess of 1,000 different first calls for data privacy / data breach events this year. So we deal with 4 to 5 net new calls every business day all year. Just to give you some context, we've probably handled in excess of 5,000 in the last decade or so, but that number continues to go up per year. So this slide here is really there to drive home a point, right? I mean, I got out of school in the 80s. Everybody collected data even back then. My first card that said I was insured as a healthcare, as an employee for a company had my social security number on it as my proof of identity and insurance. So a lot of us probably had that back in the 80s or 90s. Those of us are that old anyway. So the point being, companies have been collecting data about all of us since we were born. It didn't matter that much. And it matters now, and it matters because of the laws that were passed in the last decade or so. But most people looking at these pretty simple questions cannot answer them, most companies, because with bring your own device and with laptops and movement and the amazing growth of tech, everything has changed, everything has shrunken, and it's therefore very, very difficult to track how many copies of data are out there, how many spreadsheets, how many emails, how many deleted emails sitting in boxes, how many things in Outlook folders, how many servers with redundancy and backup, all that craziness. Next slide. So all that data collection facilitates business, right? Well, so what happens next? These 3 big buckets represent all those 1,000 claims we will see this year, right? Let's start from the bottom. For one, even if you have perfect IT, no one does, but if you did, and perfect employees, no one does, but if you did, you still have vendors who provide your payroll, who provide your healthcare service, your healthcare benefits, all of that. You ship your own data for your employees to other companies to help them help you. The cloud, a lot of people, most companies use the cloud in some way because it's efficient to use the cloud. And frankly, most clouds are extremely safe, but nevertheless, so business partners can have breaches which affect your job. Employees, we all know people make mistakes. I'm among them, right? Did you click on the wrong thing? Did you fall for the phishing attack, et cetera, et cetera? It's not that hard if you're a bad guy and you're really focused on getting into a company to do so. And then you get your malicious actors. And the short version there is, yeah, we all know about hackers, and a lot of people think, I'm not big enough to get hacked by somebody important. The way it works is they send out on the internet a search. It just says, tell me everybody who has, pick it, Windows XP. They get a number back, 5 million companies. Okay, now tell me of those 5 million, this is all automatic, how many of them have installed the last patch? Oh, 4,950,000. But that's 50,000 that didn't. Now they get focused, these bad guys. That took 2 minutes, by the way, and they're sitting in Liberia. And then they say, okay, of these 50,000, now let's take a look and see who's likely to have data we might be able to poach really quickly. And then they go from there. Point being, there is now a reason for the malicious actors, and that is there's a black market. You can buy and sell credit cards, social security numbers, names, driver's licenses, information, you can actually monetize it. So it's not just guys who want to mess with your systems or change their grade from a C to an A, like, you know, the Ferris Bueller days. It is people who want to make money by stealing data from you. Next slide. All of that stuff has been happening, but at an increasing level. So now we have all these laws, and we'll put up a slide in a moment about the laws. And the laws define what is quote-unquote protected, right? It's personally identifiable information, it's healthcare, it's PCI, which is credit cards and debit cards, and it's whatever somebody defines in a contract is as being protected. The tricky part about that is the definitions keep changing, as I will show you in the next slide. Why don't we pop the next slide? So here, now this slide, you know, merits some look. 48 states have laws. They're all different. So if you have data, and this is important, you know, my company, we're in the same boat as you guys are. We're a small middle market company, and we are subject to all of these laws. It's not where you are located. It is where the folks are located or reside whose data you possess. So if you have people that you used to employ or that used to be your clients or have moved around the country or graduated or whatever, they are all over the United States and frankly all over the world at some level, right? You are subject as a business holding their data to the laws of all of those states. When you lose data or have data compromised, and there's some terms of art in there, you have notice duties that pop up. So none of us got letters in 1995 saying, hey, XYZ company had your data and we think we lost it. We didn't get those letters. You know why? Because there were no laws saying anybody had to write them. Those letters started coming out in the mid-2000s, and they come out now with all too much frequency. But it's all driven by these state laws. And in most, about half the cases, maybe a little over half, of these 48 states, so if your company has a data privacy event, ransomware, a hack, rogue employee, a vendor breach, if you lose data, just make it for 1,000 people, okay? Likely that they're going to be in a dozen or more states. You have to deal with all those. But more importantly, you have to write those letters to them and comply with all the different variables of those states. You also have to tell the regulators in about half those states. So not only do you have to sort of raise your hand and tell your clients or your business partners you lost the data or it was compromised, you then have to tell the regulators, as under the statutes in those states, that happened. They can then choose to investigate you or not. So it is very, very tricky. Next slide, please. And all of these state laws I'm talking about keep changing. Now, if you think you have the perfect grid for state laws, you don't. Because in the last 18 months, something like 15 states have changed their laws. So not only are the laws new, meaning in the last decade, they're largely uninterpreted by any kind of case law or judge. And on top of that, they keep changing. And on top of that, the regulation, meaning the regulatory enforcement, varies from state to state. In Connecticut, in Indiana, in Washington State, in Massachusetts, those attorney general's office actively enforce these laws. I could list you 25 states that they don't do anything with it. So it just depends. Unwritten rules like this slide here, right? In Pennsylvania, I'm from Pennsylvania. We do not have a statute requiring the attorney general to be noticed. So if you lose my data and you're situated in Massachusetts, I get a letter from you. Okay, that's good. But if my AG finds out about it and you didn't notice the AG in Pennsylvania, they're mad at you and they might investigate. And when you say to them, boy, it's not in your statute, their answer is, we don't care, we want to know. In Indiana, their deadline to do notice is do so without unreasonable delay. Seems pretty reasonable to me. If you go 31 days, you're in violation, in their opinion, of their statute. Connecticut passed a law less than 2 years ago saying, if you lose Connecticut people's data, we want a year of credit monitoring, okay? So we started sending out credit monitoring, a minimum of 1 year, to anybody from Canada who was involved in any breach. The AGs from Connecticut, the AGs called us and said, you know, we want 2 years. And we said, with all due respect, you just passed a law with 1 year. And they said, yeah, well, you can do 1 year. And there was a pause. And then they said, we'll investigate your client if you do 1 year. We like 2. And the point of this slide is really, even when you think you know all the rules, you don't, because there's all these unwritten rules that we have to know and comply with. And frankly, you only get that from living it every day. Next slide. So this just gives you a sense. I don't expect anybody to know all of these rules. These are all federal laws applying to many different types of companies: financial companies, publicly traded companies, healthcare companies, or business associates of healthcare companies or insurers. That's a pretty tricky space. The FTC can come after people, and they do so all the time. The most active enforcer on the federal side is by far, not even close, it's the HIPAA guys. It's the Office for Civil Rights up near the top of this slide. They will, and it's unofficial, but anytime any company loses more than 500 records subject to HIPAA, they're getting investigated by OCR. And OCR might wait 6 to 9 months before they even ask any questions, but eventually they come a knocking. And that's a whole another year or more of investigation and cost and stress that comes from dealing with OCR as a result of a breach where you lose that kind of data. I'm often asked, hey John, is there going to be a national law that simplifies all these crazy 48 state laws? The answer is unlikely, right? For one, the administration now is not regulatory friendly. We know that. Two, we had, you see at the top of the page here, back when there were only 47 as opposed to 48 state laws, all those attorneys general got together and agreed on something. Think about that. That's 47 out of 47 state attorney generals agreeing on something. That never happened. But here it did. Why did they agree on something? They wrote a letter to Congress. They said, look, if you guys ever pass a national data breach law, do not mess with our laws. It's okay if you pass one and you pass it and it enhances our laws, meaning it overlays them, but do not pass one that tries to presumptively knock those laws out and replace them. We will not be replaced. We will not be ignored. So just think about that impact on that position on all the people in Congress. It's highly unlikely that senators and congressmen from those states are going to want to go to war with their own attorney general's office, many of whom are in the same party. So just collectively looking at the big picture here, I just don't see it happening. And if it did happen, meaning a national law, in all likelihood it would be in addition to, not instead of, 47 state laws. Just to make that point a little more clearly, when Anthem had its monster data breach, they're a big insurer, 86 million records a couple years ago, healthcare information. Not only did Anthem have a HIPAA problem, they had to deal with all 48 state laws. So it's not one or the other, it's both. Next slide. I'll go quickly through this. The payment card industry is a different regime. It feels like legislation. It feels like regulatory enforcement. The reality is it's all driven by contract, which you sign the minute you agree to take credit cards. And you have almost no power, and they will take you through an entire investigation, and your head will be spinning. And they will then decide if they're going to fine you or not based on was there fraud related to the cards that were lost. Now, all of that is without due process, and a lot of it comes from being audited by them. So it's very, very tricky space. It just, the bottom line on PCI, if you take credit cards in your business, make sure you're PCI compliant and make sure you call your lawyer and broker before you hire the PFI investigator that would be suggested to you by Visa or MasterCard. They are not your friends. They are an auditor who will report on you to the card brands and decide if you're going to get a big fine or not. Next slide. So what happens if there's a breach? So here's the short version, and I'll assume for now that you have a policy in place with Schinnerer, who's on the line. That's the broker on the line. If you have their policy, you have a problem. Let's say ransomware hits tonight at 5:30, and 20 of your 30 computers freeze, and you get a note saying we need this many Bitcoin. What do? Well, first of all, you call the 800 number that you've been given and keep it somewhere other than just in the computer, because if every computer is frozen, you may not be able to find it. So you call that number. What happens? You'll hear a voicemail that'll say, hey, you've reached the Schinnerer hotline. Please leave your name, policy number if you have it. 2 numbers, we can call you back. You'll get a call back in 2 to 4 business hours. The beauty of that is you're not going to wait 2 to 4 business hours. And if you call it after hours, you're not going to wait either. You're going to get a call back in 20 minutes or less, and it's going to be somebody from my firm saying, hey, we already got your message. Can you talk at 7 o'clock tonight or 7:30? You're going to have a situation where you are highly attentive, right? Because you just had all your computers frozen. You're going to say, yeah, 7:30 is great. Let's do it. By that time, the Schinnerer folks have already flipped me a note saying, yep, there's a policy in place for this entity. Here's the coverage information. They have pick a number, $5,000 deductible, $1 million policy, get rolling. And by the way, John, the policy for you guys, meaning the lawyers, there is no deductible. It goes right to the bottom line. That's a typical scenario, and Jason can weigh in on what that looks like. But the beauty of that is you're calling an 800 number given to you in the context of insurance. Does anybody really think they're getting a call back at 5:30 after hours? No. Do they? Every time. You'll be on with us within the hour, and then soon after that, we will have you on with forensics that night, getting you immediate forensic help remotely. And that just
John,
doesn't happen in the world. Yeah, go ahead. Is that
it's
Matt?
Matt. Yeah. So I can testify to that. There have been several cocktail parties on Friday nights that I have walked away from because that's usually when these events seem to be called in, and I've walked away from them to go back, get onto the computer, and get you a policy and number and information about the policy.
Yeah, and it works a little bit like a ballet. It sounds ridiculous as an example, but it really is true because there are multiple moving parts. While Matt and the folks that he works with are getting me that information, I've got an assistant already lining up the call. Then I'm on that phone call when it's set up over the bridge with one of my partners, giving you guys a comfort level. And the first thing we say is, guys, we're your lawyers. We are not the lawyers for the insurance carrier. We are your lawyers. Attorney-client privilege is in place immediately. And what can we do? And then tell us what's going on. We then ask a bunch of questions. We come through. By the time that call is over, we've already emailed the forensic guys saying, we need you ready for a call at 8:15. So now we started at 7:30 with you guys, right? By 8 o'clock, we were wrapping it up, and you guys are like, oh, yeah, absolutely, we need forensics, and we're so happy you can get that. Can you get it to us by tomorrow? And I'm able to say, I can get it to you in 15 minutes. Everybody take a bathroom break, grab a bottle of water, get back on this line, 15 minutes, and we're going to get you rolling through a scoping call. We then take you through a scoping call with forensics. We hire them. You don't. You sign off on it, but we hire them, keeps the attorney-client privilege in place. If we think there's going to be a public relations craziness, we'll deal with that too. We can bring in the public relations firms. It's always better to prep and not need it than not to be prepped. But think about it. You have exposure because if you have 30 people, 40 employees, 30 of them have computers frozen, you live in a small town, they all go home, they're telling their spouses, they're telling their buddies, yeah, our computer system got frozen today. Next thing you know, someone says the wrong thing to the wrong person, and the local Channel 6 News is at the door in the morning. It happens all the time. So better to prepare. Anyway, we take you through with the forensics. We get them rolling. Their job is to get you safe and eventually tell us what happened. While we're monitoring and controlling all that, we're trying to figure out, do you or do you not have a duty triggered by this event? Meaning, do you have to write letters? Do you have to tell Attorney General? Do you have to offer credit monitoring? All that kind of stuff. Let's just assume you do, only to make the point, right, to play this out. We then bring in, again, under your policy, the vendors that do the mailings, conduct the call centers, sign people up who are your clients for credit monitoring, all in one call, all without waiting for more than 30 seconds on hold. The whole idea there is to comply with the law, but also to not further aggravate people you now have to give bad news. When you do all of that, you sort of you cross your fingers and hope that you don't get a regulator come knocking. I will tell you, 70% of the 1,000 cases we have this year will have a regulator ask some questions. That doesn't mean they're taking you to the woodshed. It just means they're asking some questions, and you've got to do some responses and be cautious about it and treat them with respect and give them what they need. And 99% of the time, they pick on somebody else, frankly. So that's the really short version of what we do when a breach call comes in, all the while coordinating with your broker-chauffeur to make sure that everything is going through smoothly, that your coverage is covering all this. And I will tell you, everything I just said to you, lawyers, forensics, PR, mailing, credit monitoring, all that stuff is covered by the policy. Chauffeur will make sure that all happens smoothly, but that's why one of the reasons you buy this policy, because everything I just said to you can happen within days, if not a week or two. It's not like litigation where it's a 2-year ordeal. This thing happens quickly. It's days, some weeks, and it's largely done unless the regulator comes knocking. Or in the really rare case, you get sued. So I will tell you, less than 1% of the cases we see have a lawsuit. I think that's going to tick up because the law is trending away from the defense. But for now, it's still a relatively low percentage. Next slide. And by the way, Matt, if you have any questions or thoughts as we go through this, jump in, because people probably get sick of hearing just me talk. We've got about 10 minutes left. This is just in here to show you quickly, guys, that it used to be easy to win lawsuits in this space by saying, look, they're alleging possible future data theft. That's not enough. Well, nowadays it is enough in these circuits. So as you see, I used to call this defense is eroding. Not as easy to win these cases as it used to be. Still winnable or settleable. No one's ever gotten to a jury in this whole country on these issues, but they're more expensive to settle today than they were 2 years ago. Next slide. You know, and these are just more, and again, you can have these slides. These are just more examples of some settlements that have been happening, and frankly, the reason the settlements are happening is because people are hesitant to take that jury verdict. You also don't want to get into a heavy discovery scenario when you've already had, in effect, a breach. The discovery process during litigation rarely helps the defense. It always makes you look worse. So we try to avoid it like the plague. Next slide. So what kind of best practices, you know, and this really does apply to smaller and mid-sized businesses. You've got to put someone in charge of the situation. If someone's not in charge, then no one's in charge. So put someone in charge and say, if this happens, you need to be running this show. So you've got to talk to people. You don't let IT alone do it. Somebody more operational should be the actual boss. You should have an outside company come in. They're not expensive if you get the right ones to assess and test how well your security and IT is being handled, your training. It's not just IT. It's training. It's policies and procedures. It's all that. Document all your efforts, and then really, again, I would say this if I weren't on the phone with people who are in the world of insurance. When I get these calls, 1,000 a year, people are freaking out. They think their business is going to close. They think they're going to get fired, or somebody else is going to get fired, and most of them are insured. Just imagine the level of stress times 10 when you're calling without the backstop of insurance. When I opened my own firm a year or so ago, I refused to open the doors until I had security and until I had insurance in place. So just keep that in mind. Next slide.
Hey, John. When you talked about your slide says that your slide says that it's enable the executives, but you said have someone in charge. What happens when you don't have a single person in charge?
Okay, so or you don't have the person who's running the response with enough authority is another way to think of it. So here it is.
Right.
So Schinnerer themselves has a breach. They put Matt, who's on the phone with me now, in charge. I get on the phone with Matt on that Friday night at 6 p.m. No doubt it's obviously going to be a holiday weekend, right, Matt? And I say to you after an hour, you need forensics and you need them now. And you say to me, I have to get a hold of the boss. He's not available tonight. He's at this or he's at that. We can't do this till tomorrow or Sunday. That's a problem. And that's typical of what we see. People, the boss, will often delegate the responsibility, but not the authority. So if you're going to make Matt in charge, then Matt has to be able to say, yes, go for it. We'll sign off on hiring you and signing off on hiring the forensics immediately. So the person who's in the role of Matt, meaning the person who's spearheading this frantic response, needs to be able to make those decisions right then and there. So hopefully that helps.
Yeah, and we did have a circumstance where the boss was on vacation, and we kept hounding the client, and there was just no prioritization to get you rolling on one of our claims.
That's right.
That's right. Does that happen? Do you find that happens a lot in the small and middle market space?
Yeah, it happens if you don't have the right authority on the phone. Yeah, because people are frozen, and rightly so. You know, it's hard to commit your company to a course of action when you're not the boss and you don't have the authority to act because you're worried. You're already stressed because of the event, and on top of that, if you make the wrong move, you could lose your job, you could hurt the company, etc. So we see it a lot, which is why seminars like this help, because a fair amount of people who ultimately we talk to have heard a seminar like this at one point, and they have a sense of it. So I know we only have a minute or two left. Looking at this, It's important to have an incident response team, meaning some kind of plan. What's going to happen? What do we do? Look, even if it's just one page and it basically says, call this 800 number and call our broker Shinura, well, that's better than nothing, guys. And I like it because if I'm defending or a regulator says, well, show me what their incident response plan was. We want to make sure that this company took data security seriously. Where is it? And I want to be able to say, here it is. And it could be as simple as that. It could be one page long. You can go on the eRisk Hub and you can find it, and you can find an example of it, and you can craft it a little bit and make it your own. Use legal counsel. Obviously, I'm preaching to the choir here, right? I'm telling you, I'm a lawyer telling you to use legal counsel. The reality is that is the standard in the country. We are able to provide attorney-client privilege to all the vendors you would use, the people who would be handling call centers, including the content of frequently asked questions and answers, all the communications with vendors, regulators, etc. So that's why the insurance carriers pay for the lawyers, because they want that privilege in place. Next slide. These are just some points. Try not to say breach, because you don't know it's a breach. To me, as a lawyer, it's not a breach until I tell you it is. It might be a data privacy event, but to me, a breach means you've now triggered legal duties. You now have to tell people. You don't want to jump too soon. You don't want to start saying, oh my God, our whole database, we have to mail to everybody. Wait until we know what's really going on. Assume you can get sued. Don't, by no means will you, but assume you can get sued and preserve all the data that you really need to do. And then get those risk assessments done, once a year, once every 18 months, and then make a plan around them. You're not going to be able to fix every risk that you identify in your company in day one. People have budgets. People have priorities. But if a regulator asks me for one and I can show them that you did a risk assessment and that based on that you fixed the easy ones and you made a plan for the more expensive ones, okay, they know you're not perfect. They just want to see an effort. Next slide. And this is it. So that brings me back to Matt or Jason, and you guys can sort of tie this thing off.
John, this is Jason. I did have one quick question for you. Would contacting of the breach coach, calling that 1-800 number, would that constitute notice under a policy or under a program typically?
I'll defer to Matt on that. Generally speaking, in the industry, it does not, and the reason it does not is because they don't want companies who are insured, worrying that it's going to somehow hurt next year's premium. Because they might call when they're just not sure. And I'm often asked that, I think you guys are too. Hey, how do we know when to call or not call? And the answer is, if you think you might have a problem, call. If we end up talking to you for an hour and then saying you don't really have a problem, okay, that's fine. But Matt might have another thought there.
I mean, that's absolutely the case. We want people to utilize this as soon as they think there's an event. You don't have to prove it's been an event. You just have to think there was an event to pull, Mullen and Coughlin into this. That way you get immediately rolling down the path of finding out whether or not it really is. They can do the assessment, decide whether or not forensics are needed or not. But the point is to get it involved early, hit it fast, take care of it quickly. John mentioned it a couple of times, getting people taken care of. If there's been an event and you do have to do some reporting, don't let that clock run. Making sure you don't aggravate people by letting things run out and stretch out who may be impacted. So that's the thought process in this particular line of insurance.
Hey guys, it's Jillian. I'm going to interrupt real quick. I just wanted to get to the couple questions that came through before we run out of time. So the first question is there a coverage problem if an insured experiences a breach but is not 100% compliant with the state or other regulatory bodies? For instance, there was a medical office that wasn't completely in compliance with HIPAA's rules regarding backup and storing data. So is coverage in jeopardy?
Well, I can tell you from my perspective, this is John, and I don't do the coverage piece, but I can pretty much assume that almost every breach we have, somebody's not compliant with something. That's why they had the breach. So I am unaware in virtually any case I've handled in a dozen years of that causing someone to not have coverage. And the brokers on the call can weigh in on that.
Okay, correct. This is Jason. Our policy form does not have any conditions or exclusions or anything pertaining to non-compliance with either HIPAA regulations or PCI compliance expectations or requirements. So being non-compliant should not negatively impact the coverage. And further, our form does include regulatory fines, penalties that may be levied against the insured. So some of those fines may be coverable by insurance.
Right. And generally are, frankly, from what I've seen.
Another question that came in asked if there are different steps that they need to take if the breach comes through on a computer, a laptop, or a phone, or a tablet. Does anything change?
I mean, so the answer is there are variables constantly with every different fact scenario, but the basic method that we laid out, which is identify a problem or a possible problem, call the 800 number, get on the horn with us, confirm your coverage, and we'll do that with the folks on the phone from Schinnerer, and go through that process. Whether it's a phone or an iPad, a computer, or a lost box of paper, it doesn't really matter. The process is the same. The fact patterns are wildly different, but that doesn't change the basic process.
Okay, one other one. What are the biggest mistakes you have seen after a breach? What are the biggest mistakes people make after they have a breach?
Well, from my perspective, it's mismanaging the SAR. So if they have a $5,000, a $10,000, a $20,000 SAR, people are afraid to spend it, not realizing they might have a $200,000 problem, and then they delay or they make bad decisions. So that's one. Another is if you have an outside security firm helping you with security, those aren't the guys to call when you think there's a mess up, because they come in from the regulator point of view, and they're viewed as doing CYA instead of helping you. So if you think about it, if they're supporting you for IT security and you have an IT security problem, it may be their fault. So, go through the process. We'll get you the right forensic guys. So those are two things that jump out pretty quickly. Matt, I don't
Final
know if you have
question. Oh, sorry. Okay, final question came through regarding all of the different state laws and rules. Is there a place they can go to find them? I know you mentioned they're kind of unwritten, but are they written anywhere?
Yeah, they're written in 48 different states, and they keep changing. So, no, there's not really a place, and even if I pointed you to one, somebody would probably change the law tomorrow. And that's the problem, and that's the complexity, right? The minute you find a grid online, it's probably outdated. So I'm sure there's a million firms and there's a million spots on the, out there that you can just search, 48 state data privacy laws, and you'll find something. It'll be a guide, but don't bank on it being perfectly correct or capturing those unwritten laws, because those won't be there.
And it should also be noted that some laws are federal versus state. So, for example, HIPAA, those may have a different impact, statewide, or may have a different impact, I guess, depending on the scenario.
Yeah, for sure.
Okay, I know we're a little tight for time here, so I will cap the questions there. If we did not get to your questions, we will address them via email. And if you do have any questions later on, please do reach out to Jason, Zach, or Mark. If you have a specific question for John, we can also relay those questions to him, and he can get back to you. Anything else to add, John, Matt, or Jason?
I just want to say thank you so much to John for coming in and joining us today. He is pretty much a world-renowned privacy expert on all things privacy, and it's a real privilege to have him come and join us this month. And we really do appreciate his insight and expertise.
Happy to help.
Wonderful. Okay, thank you all very much for joining, and have a great day.
Thank you.
Thanks, everybody.